All right? So listen up, we'll go through it a little quicker than I did earlier. We started out with forms of business. Partnership or corporation. And then 5 decision makers. Capital, ease, control, taxation, and liability. Remember, this review is for your final exam. So what you write is, this is a form of business issue. These 4 people need to decide between a partnership and a corporation. In order to make that decision, they have to go through the 5 decision makers. 1, 2, 3, 4, 5. Don't make me read the whole paper to find the 5. Tell me up front what 5 of them are. Then apply each one of them to whether you have chosen a partnership or whether you have chosen a corporation. If you have time, it's a long test. If you have time, say if you choose partnership and you talk about capital, ease, control, taxation, liability as it applies to the people's business, if you have time, then tell me why it doesn't apply to the corporation. That's just kind of extra points. It applies to a partnership. Partnership's easy to control, hard to get capital, good taxes. Okay, but then if you have time, say this would not be a good business for a corporation because maybe it has no liability issue. Don't forget that the liability that is the main one, because if you are making a product that can hurt somebody, that takes precedence over the other 4. Okay? If you think you're going to have any liability, then you need to choose a corporation in order to protect yourself. This is a chart I did the first week of class. I redid it this morning in case you don't remember it. We've got partnership, corporation, and then across the top, the 5 decision makers: capital, ease, control, taxation, and liability. And then you look in the matrix, you see that partnership, capital is bad because you have to get personal money or a loan. Capital for corporation is very good. You can sell stock. Ease of creation is good for a partnership, but is bad for a corporation because you have to go through a bunch of paperwork. Control for a partnership is great. I mean, you and your partner can decide, whether you want to make red hats or blue hats. I mean, it's easy to make decisions when you just are in partners. Control in a corporation is a little harder because you have stockholders. And stockholders meet once a year and vote as to whether you're doing a good job running the business. Tax for a partnership is a personal rate. Taxation for a corporation is double taxation. Don't be embarrassed. Does anybody not understand double taxation? Okay, good. And then finally, liability. Liability is terrible if you're a partnership because you are sued personally. If your truck runs over somebody, they sue you. Liability is great if you're a corporation because you have a corporate shield. You sue the business, not the individual. We next did basic business equation, which is profit equals revenue minus expenses. I can't hardly think of a question that you couldn't use that sentence. I mean, if any business you're founding, any business that I give you, any business that I talk about, it doesn't matter if they're getting sued or if they need management or what it would always, you can always say, this business needs to make money, and to do that, profit equals revenue minus expenses. That one sentence can go in just about any answer and fit. Next, we did ethics. I was doing some research this weekend and ran across an author of a book who said that ethics is do what's right when nobody's looking. I mean, that's a pretty famous statement. It's not something I made up. And there are three kinds of ethical standards: religious, moral, and situational. These are standards. So if you have a religious standard, it means that you do what's right when nobody's looking because of your religion. It doesn't matter whether it's the Bible or the Koran or the Talmud, but there's something in your religion and in your background that makes you think that, that it's moral. I guess it could be Vikings. Moral is, we all have a basic sense of what's right and wrong. And that psychologists have proven that through polls and tests and all through, much older than me, older than you. People have a basic idea of what is right and wrong. Even children have a basic idea of what's right and wrong. Right? So if your standard is not religious, then your standard would be moral. That is, you just kind of generally know what's right and wrong. Situational ethics are bad. That is, you change what you believe based on the situation. When I first got out of law school, I was the assistant city attorney to the city of Greenville. Had my office in the big Greenville City Hall. I had one boss who was the city attorney, and there was one other attorney in the office, and then a couple of secretaries. The other attorney was female, a little bit older than I was, and then I was right out of law school, and my boss had been city attorney for 20 years. One day, he said, about 1 or 2 o'clock, he said, "Come on, let's go play golf." And he and I left the office and went and played golf. About 2 weeks later, it snowed. The female attorney came in late, about 12 or 1 o'clock, and he docked her pay for being late. Right? Now, that is situational ethics. All right? That is situational ethics at its worst. That had anything to do with male or female. That was just terrible. He's taking me to play golf and then docking her pay because she's late in the snow. That's situational ethics, treating people different according to the circumstances. We then did management. A management issue is if I give you a task that says you have formed a business of any kind and the business is having financial trouble under the basic business equation, and they need to hire some new managers to run the business. All right? Don't just let that fly. That's a hint. This is also a management issue. The new manager should do a SWOT. Strength, weakness, opportunity, and threat. If I tell you that the business you formed is having a hard time with a competitor, that a competition is really hard, and a new product is eating into your products, so you do a SWOT and you talk about the threat. Talk about what is your strength, what is your weakness, what is your opportunity, and then in that case, the threat would be the competitor. And if you say, this is a management issue, they need to do a SWOT, and the threat is the competition, that's an A paper. You also have strategic, which is the future. A SWOT is a present decision. The strategic in business is usually 3 months, a year, or 5 years. And looking down the road. Benjamin was just asking me about opening a bar. I will do research this weekend. And 80% of small businesses fail after 2 years. It used to be after 3 years. Now they're failing at a quicker rate than they used to. And so strategic planning, what are you going to do for 5 years, is what a bank is going to want to know, is what a venture capitalist is going to want to know, before they give you money, is what's your plan 3, 4, 5 years from now. Because most businesses fail after the second year. Situational management is just like situational ethics. It's bad. All right, contracts. Contracts and torts are like the basis of this class. Both are very, very important, but contracts is really easy. Okay, it's not a hard concept. A contract has to have offer, acceptance, and consideration. It has to have all three of them. Consideration is value, dollars, or something bartered, and a contract has to have all three. Okay? Now, they also have to have competence, which is age, nobody disabled, somebody with authority. Somebody can't walk into a building as a courier and say, I need to get this contract signed so I can take it back to my boss and have the receptionist sign. Okay, they don't have authority. We have not gone over that a lot, so don't worry about it. Offer, acceptance, and consideration. Torts. A tort is an injury to a person or a business, not a crime, which is an injury to the public. Don't get torts and crimes mixed up. Torts are an injury to the public or to a business. You have duty to a person or a business. Duty to the public, person or business, and it results in an injury. Everybody should know that. That's easy. That's like offer, acceptance, and consideration. You should have written down somewhere tort, duty, public, injury. 3 things. What you're tested on is whether the duty is reasonable and whether the injury is foreseeable. Those are things that you don't know. Those are things that have to be decided. So if I give you an example of somebody slipping and falling in Walmart and hitting the head on the back of the door, that's a tort. Walmart has a duty to keep their floors clean to the public, and they have, if you fall, hit your head on the floor, you're going to be injured. So then the issue is it reasonable? Did the facts that I give you, was it something like out of the produce aisle, or was it where a child, a baby, had thrown up and nobody knew it was there? They don't have a duty to clean that up immediately. Okay, they have a duty to clean it up, but maybe not immediately. The injury, broken arm, busted head, but not heart attack, not paralysis. You know, what's foreseeable if you fall down? Now, you can't tell me what is reasonable or what is foreseeable. You tell me this may or may not be a reasonable duty. It is reasonable, but the floor should be clean. It may not be reasonable to clean up a baby's mess. It is foreseeable that somebody would be injured if they fell. It may not be foreseeable if the injury was very, very gross, very, very bad. All right, so give me what I need to know that you understand. property. Property is personal property and real property. Personal property is very easy. It's like contracts. 1, 2, 3. Ownership, possession, and title. You have to have all three. Ownership, possession, and title. The best example is the used car dealer who buys used cars at an auction. And he puts them on the back of that 18-wheeler and takes them to his car lot. He sells the used car to you, and then you say, where's the title? And they say, well, you know, the auction's going to send it to me. Well, the auction's not going to send it to them because they don't have it. Right? Auctions rarely have those titles. Maybe the car is stolen. So when you buy a used car, you often have to go to the motor vehicle division to get a lost title. And until you have that title, the car is not legally yours. Ownership, possession, and title. Real property, land, and fixture. A fixture is something that's built on the land, like a barn on a farm. You can move the tractors, but you can't move the barn, so the barn is a fixture. The way you get real property is a grantor sells to a grantee. And the way they do that is by deed. And that deed must have a property description. And the property description describing the metes and bounds of the property has to be the same for 70 years. If you're going back looking at that piece of property and you find a property description that's different, then you got a problem, and that has to be fixed. This right here, the grantor grantee deed, property description, that's enough for a B+ paper. You want an A, you may need to say that the property may have an easement, which is a small access to property behind it, like a dirt road. Adverse possession is a small piece of property on the inside of the land. The easement is easy to fix. The easement, you say the corporation can buy out the owner. Just buy them out. The adverse possession, you sue. Okay? Because adverse possession is almost impossible to prove. So somebody says they've been living there for 25 years, it's hard to prove that. If they go on vacation, they lose their property. So do it. Also, we talked about eminent domain, which is when the government puts a road and takes some of your property. They can do that. Absolutely they can do that. That's called eminent domain. But they have to pay you just compensation under the Constitution. And that doesn't mean they have to pay you they just have to pay you money. Not like just compensation. It means just like justice compensation. Human resources. We did flow charts. Right? We did horizontal. We did vertical. But we mainly did the human resources circle is what I call it, when you got human resources in the middle. And start out, they plan. Then they recruit. Then they train. Then they evaluate. Then they compensate. And then they hire or fire. And it's just a constant process of hiring, planning, training, recruiting, evaluating, and starting all over again. Okay? That circle is usually a 90-day to 6-month circle, and they just kind of keep going over and over. Any questions on what you can see? Everybody get pictures? Everybody take notes? We next did damages. Oh, by the way, this is very important. I'm sorry I didn't say it. When you're doing torts, and we're doing the torts, tort system up here, you don't need to take it all the way to trial. You can stop it at the alternative disputes. We'll talk about that in just a minute. Damages. Compensatory. Compensates you for what you've lost. Consequential. That's other damage. These are actual damages, money that you're out. These are attorney fees, lost wages, etc. Nominal. $1. The plaintiff wins, and the jury says, well, you win, but some of it's your fault, and we're only going to award you $1. And then punitive. To punish. And that's where you get somebody, $5,000 for the car wreck and $1 million because the person that hit you was drunk. And so you get punitive damages. Finally, civil litigation. Civil litigation is not criminal, just like a tort is not a crime. Civil litigation starts out with 1, cause of action. Why are you suing? It's going to either be, for your class, your exam, a tort or a breach of contract. It's going to be one of those two for the cause of action. Secondly, what is the jurisdiction in venue? Is it federal or state? What puts it in federal? Over 75,000 or 2 states. And what is the state jurisdiction? Everything else. So you say Corporation A is going to file a lawsuit for a breach of contract against Corporation B. It's for $10 million. So the jurisdiction is going to be in federal court. And the plaintiff, Corporation A, is going to file a complaint complaining that Corporation B owes its money. The defendant, Corporation B, is going to file an answer denying that it owes its money. The defendant then may also file a counterclaim. Not only do we not owe you money, you owe us money. And then if that happens, then the plaintiff files a reply. Here's your big word for the day, pleadings. You've got to have that word in your exam. Because without the word pleadings, you can't have the word discovery. Discovery does not happen until all of the pleadings have been filed. Discovery is exchange of info. All the witnesses, all the evidence, everything that each party knows that you get to know in a civil litigation. Unlike criminal where you don't get to know everything. All right? That can be done in person by a deposition or can be done written in an interrogatory. Now, after discovery, you go to alternative dispute resolution. Why do we do that? Because time equals money. Between right here and a trial, we've got another year to go. Corporation A can't wait a year for $10 million. Corporation B can't wait a year to know whether it's got to spend $10 million. So alternative dispute resolution is based on time equals money. The first is negotiation. The two attorneys discuss it. It is not final if one of the clients doesn't want to pay. The second is mediation. A mediator, just a pretend judge, has a little pretend trial and reads all the discovery, talks to all the witnesses, and says, I think Corporation B needs to pay $10 million. Right? But it is not final if Corporation B doesn't want to do that. Finally, you get to arbitration. Arbitration is final because you sign a contract saying, I will take whatever the arbitration says. Even if you don't get what you want, you have contracted away your right to trial. Contracted away your right to trial. And why would you do that? Because time equals money. All right? Now, after alternative dispute resolution, you would go to trial. I will not test you on that. We're not going to go through the jury venire and the petty jury and the motions to the judge. Once you do alternative dispute resolution, tell me the next step would be going to trial if they didn't go to arbitration. If they went to arbitration, it's over. If they don't want arbitration, then the next step would be trial, but you don't have to tell me how to get there. That's everything we've done. All right, that's everything we've done. Please, 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 please have your little check sheet so that you can check off forms of business, civil litigation, check off management, check off contracts, so that you know what's in there.